Welcome to this free presentation from Johnson's Solicitors. Compulsory early conciliation via ACAS, what you need to know. This presentation concerns important changes to UK employment law. Every employer and every employee should know about these changes. Please watch this presentation and share it widely. What is this about? It is about the new compulsory or mandatory conciliation before issuing Employment Tribunal claims. Who needs to know about it? All employers, all employees, personnel and human resources professionals, unions, and of course lawyers. Where is the law? The law is to be found in the Enterprise and Regulatory Reform Act 2013. It is sandwiched in between provisions about the Green Investment Bank and the Competition and Marketing Authority. Not the obvious place to find very significant amendments to UK employment law. This is a free presentation because every employer and every employee needs to know about it. That is a lot of people. Please share this. Share it on email, on Facebook, on Twitter, and on LinkedIn. The key issues that arise from these reforms are that the Employment Tribunal will not accept a claim unless the claimant has informed ACAS and can produce a certificate to prove it. And time limits for making claims may be extended. Yes, that's right. A person may not present an application to an employment tribunal without a certificate from ACAS. As you might expect, there are exceptions to this. The law applies only to relevant proceedings, and some relevant proceedings are excluded in certain circumstances. Relevant proceedings are set out in Section 18 of the Employment Tribunals Act and include most claims that can be made to employment tribunals. With regard to the exceptions set out here, where the requirement is complied with by another person, then it is not necessary for others within the same category to comply with the requirement. The best example of this would be where an employer made a decision that affected a group of employees. If one of them complies with the notification procedure, then it isn't necessary for each of the others to do so. Secondly, if proceedings are issued that are not relevant proceedings at the same time and on the same form as relevant proceedings, then there is no need to have gone through the notification procedure. The reason for that is because the early conciliation process only stops time running on the limitation period in relation to those relevant proceedings, and clearly that would be detrimental in relation to the non-relevant proceedings. Finally, there's a reference to Section 18B of the Employment Tribunals Act 1996. This deals with a situation where the employer has already contacted ACAS to discuss matters that are relevant proceedings and relate to the claim to be issued. Before this Act came into force, the time limit for making most claims before an employment tribunal was 3 months from the Act complained of or the effective date of termination of employment. In the case of claims for redundancy pay, that period was 6 months. These periods gave employers certainty as to when they may be at risk of a claim from an employee or a former employee. The Act does not alter the statutory time limits as such, but it provides for the extension of the limitation period to allow for the early conciliation to take place. How this works is set out in a schedule all of its own, because it amends the wording of the time limit provisions in each statute individually. Here we have tried to simplify the time limit extensions. First of all, where day A is the date when the potential claimant notifies ACAS, and where day B is the date when the potential claimant receives the ACAS certificate, then in working out when a time limit expires, the period beginning with the day after day A and ending with day B is not counted. The effect of this is to extend the limitation period by the duration of the conciliation period. That would be fine as long as day A was close to the beginning of the limitation period. However, if day A is near the end of the limitation period, then there would be a difficulty because day B would be either close to or after the limitation period had ended. In order to avoid the problem, a further provision provides that if a time limit would, if not extended, expire during the period beginning with day A and ending 1 month after day B, then the time limit expires instead at the end of that period. The effect of this is that there will always be at least a month between the end of the conciliation period and the end of the extended limitation period. This gives the employee time to issue proceedings. Here is an example of how this would work in the case of proceedings issued very soon after termination of employment. You will see that the period of time between day A and day B in this example is 31 days, and therefore the time limit is extended by 31 days. In this example, we have a notification to ACAS, which is not given until the 10th of July, where the employee had been dismissed on the 6th of May. Although in this example, the conciliation period is only 13 days, which is likely to be because the conciliation officer had issued the certificate on the basis that the parties were clearly not going to reach agreement. The limitation period in this case is extended by a month from day B, and therefore it is extended to the 22nd of August. In this example, the employee is notifying ACAS on the very last day of the limitation period. And again, the provisions apply so that the extension is by a month following day B. This takes the period, in this case, to the 5th of October, which is some 2 months after the end of the normal 3-month limitation period. The obligation isn't actually to engage in compulsory conciliation at all. The obligation is to notify ACAS, and if a person attempts to present an application to an employment tribunal without first giving the prescribed information to ACAS in the prescribed manner, then that claim will not be accepted. This is essential, as without going through this step, the employee could lose their right to bring a claim at all. The tribunal online claim process will request the ACAS certificate number, and so potential claimants will be prompted to provide the prescribed information to ACAS. This may be difficult if the attempt is being made to make the claim online close to midnight on the final day of the limitation period. Those issuing by post close to the expiry of the time limit will risk being out of time if they haven't notified ACAS. To notify ACAS, a potential claimant can either complete the online claim form, which is the method that ACAS prefer, or can telephone ACAS. At this point, ACAS require only the potential claimant's name and address, contact telephone numbers and email address, the name and address and telephone number of the employer. They also ask for the date the employment began, the date that it ended, if it has ended, and the potential claimant's job title and the date of the act complained of. When this notification is given, this will be day A. It is important to get the name of the employer right, because that is the name that will eventually appear on the ACAS certificate. And it is important that that is correct, because that will relate to the tribunal proceedings that may subsequently be issued. ACAS should contact the potential claimant within 2 working days of receiving notification. They will then try to get basic information from the potential claimant about the dispute, and they will also explain the early conciliation procedure. The case will then be passed to a conciliator, who will try to contact both parties and to talk about the issues to see if a solution can be found. The conciliation period is initially 1 month, but the parties can agree to extend this by 14 days. Only one such extension may be agreed. At the end of the month, or the month and 14 days, the conciliator will close the conciliation process and issue a certificate that early conciliation has ended. If a settlement is reached and no tribunal claim is to be issued, that will be the end of the matter. It is possible that a settlement could be reached on some issues, but not on others, in which case there will still be a need for a conciliation certificate, and the matters that haven't been settled can then proceed to be considered by the tribunal. Although it is compulsory to give early notification to ACAS, there is no obligation on either party to participate in the conciliation. If the conciliator concludes at any time that settlement can't be reached, then she or he will issue the certificate that early conciliation has ended. In these circumstances, the conciliation period could be less than 1 month, although in practice it is expected that most conciliation periods will last the initial monthly term. The certificate that early conciliation has ended will contain a unique reference number, and this will have to be supplied when issuing any employment tribunal proceedings. This is the way that it is proved to the tribunal that the early conciliation process has been begun and ended. There is nothing to prevent the parties continuing to use ACAS to conciliate after a certificate has been issued, but time will then be running. Settlements concluded through ACAS during the early conciliation period, or indeed at any time, will be recorded in a form COT3. This is the standard form for recording settlements negotiated via ACAS, and lawyers and other representatives will be familiar with it. Both parties are strongly advised to engage legal representation. The lawyers for both parties will need to exercise great skill and care in negotiating the terms of the COT3 agreement. There is of course nothing to prevent the parties from negotiating a compromise agreement instead of a COT3. There is no restriction on the terms of the settlement that may be negotiated, and one of the advantages of reaching a settlement without the matter going to a tribunal is this greater flexibility and control over the terms of the settlement. This can be advantageous to both parties. However, in the case of a potential unfair dismissal claim, the ACAS conciliator is directed to promote the reinstatement or re-engagement of the employee, unless the employee does not want his or her job back. In practice, many employees don't want to return to work for an employer who they believed has treated them unfairly. However, some may prefer to return to their old job or to another job with the same employer on no less favourable terms, rather than face the uncertainties of unemployment. Thank you for watching this presentation from Johnson Solicitors. Please share it with others